start with section 101. We did section 100 in last lecture.
100 समझे तुम? हम 100 का मतलब क्या है?
Yes, sir, we did 100. Savings
क्या?
of provisions of Indian Succession Act related to wills.
सक्सेशन एक्ट के प्रोविजंस मालूम है आप लोग को? व्हाट आर द
Yes, sir,
प्रोविजंस?
we did it. We did under family law.
Family law में what are the relevant section where the provisions of extrinsic evidence is not applicable under the Indian Succession Act? याद है आप लोग को किसी को? फैमिली लॉ भूल गए? नहीं ना? That is section 80 and 81. खोलो आप of the Indian Succession Act. That is chapter 6. That is the construction of the will. Just open this. I'll tell you. I will compare this to you. Come to know. Just open Indian Succession Act, please.
Sir, which section under the Indian Succession Act?
80, 81, 80.
Yes, sir, shared it on the.
Section 80 tells you extrinsic evidence admissible in cases of patent ambiguity. Now, this section 80 is equivalent to section 93, 93 of the 93, 96, 96 of the Evidence Act. 93, 96 में you are allowed to lead evidence of patent ambiguity. Now, 81 speaks of you cannot lead evidence in case of ambiguity, which is a patent. That is again examples under section 94 and 95 of the Evidence Act. Remember this. 80, 81 under the Indian Succession Act, when will is questioned, you cannot change the intention of the testator the way you want it unless the will is there is a patent ambiguity, something which can be a hidden ambiguity which doesn't destroy the intention of the testator. That can be done. That is why the provisions of the entire evidence provisions of section 91 to 100 do not apply Evidence Act, because there is a specific provision contained in the Indian Succession Act with regard to proving a will itself, that is 80, 81. Oh, that's okay. Okay. Now let us come to your Evidence Act now. Burden of proof. So how you discharge the production and effect of evidence. So this is the last chapter, part 3 of the Evidence Act. Very crucial how the document, in the earlier chapters you learned here, relevancy of facts, what is the definition relevancy of fact, then then proof of the fact. How the evidence must be, all documents, all evidence is not taken into consideration by the court of law. You will have to prove before the court first the relevancy, then admissibility, then how the document can be admitted. That you learned it, the proof of document part 2 में section 56 onward पढ़े आपने, isn't it? Part 2 के अंदर पढ़ लिए. अभी part 3, merely the fact that the document itself has been produced before the court, exhibited, is not not proof. How you should discharge your burden, whether the plaintiff or the defendant, the gentleman who asserts the rights, must step into the box. The author of the document must come and say that this is my signature, this is written by me, this is my sale deed, this is my signature, this is what I stated. ये सब चीजें proof of the evidence, production of the evidence, starting with the proof. It is both in civil and criminal cases. So normally in civil cases, the court is framing issues. I'll just close my phone, otherwise people will trouble me. Yes. Yeah. In the under the Code of Civil Procedure Code, the after the framing of the issues before the court of law, the court will direct the parties. You file your examination chief. Both the parties are hereby directed to file the list of documents. In fact, this order is called pre-trial stages. When pleadings are completed under the CPC under Order 10, the court will record evidence to ask that recording examination of the parties is with a view to find out whether any of the parties are agreeable to settle the case. What the case is about. Order 10 can there, that is examination. Then that procedure suppose fail, the court may send the matter to you for arbitration, conciliation, mediation, lok adalat under the act. वो fail होने के बाद then evidence exactly start before the court of law. The that commencement comes with your examination chief. Normally, the under the provisions of Order 18, CPC tells you who should begin first, isn't it? Of course, the CRPC in the session trial, warrant trial, summon trial, it is the prosecution normally starts the case, begins the case. Public prosecutor describes the charges before the court of law under the provisions of Section 225, 226, 7 CRPC के अंदर आपने पढ़ चुका है उसके अंदर. Then after description of the case, the court will see whether there is a material before the court to proceed or not. Then whether to frame charges or not. So CRPC follows a different route from the CPC. Then at the time for recording of the evidence, suppose normally the prosecution required to prove the case beyond reasonable doubt. So the prosecution witnesses will start be examining. You examine first the IO who conducted the investigation, isn't it? Then you record the evidence of the witnesses whose evidence was recorded under Section 161, 162 CRPC. And सबसे पहले the court will record the evidence of a victim or a person who made confession under 164 CRPC. Then accused will take up the plea. I was insane at the time of the commission of the crime. Uh, I was not there. Alibi lega. Then in that event, the burden will shift upon him. So the burden will shift upon him. So in a civil case, when you seek a declaration before the court of law, I am the owner of the property, be the trespasser, you have to prove that you are a owner of the property. So the burden will be upon you. The burden is not upon the defendant. Of course, if the court says that here the defendant has taken the plea that the court has no jurisdiction, that the defendant has taken the plea that the suit is barred by the doctrine of res judicata or some other legal point under the provision of Order 2, Rule 2, Order 23, that the suit is not maintainable. The court may be framing a preliminary issue trying on the basis of law itself. Then in that event, I think you all are not able to see me, isn't it? You all can see me, Kumar? मुझे देख पा रहे हैं आप लोग?
Yes, you are audible and visible both.
हाँ जी? You all can see me, no?
Yes, sir. You are.
Okay. So this chapter, the protection and the effect of the evidence. Whatever evidence the court has collected, the documents in the previous chapter relating to, we mentioned you can give evidence with regard to fact in issue number 1. Then court collected the evidence which is a relevancy of fact. Then in the list of documents which have been produced before the court of law, the court has passed order under the provisions of Section 135, 136, whether admissible, not admissible. That admissibility has been passed. Now, this is stage for consideration. Whatever evidence which the court has permitted the parties to lead and document which has been collected, both primary evidence, secondary evidence, and whatever all evidence before the court of law. Now the time to prove it. And you must discharge your burden. Now let us see how it starts. 1010 Elijah. Yes. Whoever desires any court to give judgment as to any legal right or liability depends on the existence of the fact which he asserts must prove that those facts exist. So here, obviously, following the provisions of Order 18, who should begin the case? Order 18, Rule 1 CPC tells you who will begin the case. Now, the criminal prosecutions starting from the provisions of Section 225 onward, that is a session trial, warrant trial, then summon trial, ending with Section 260 onward, that the prosecution will start. Now, यहाँ पे the burden is upon the person. So, CPC tells you who should start. Now, whoever, it is not mandatory always that the plaintiff who has filed the case, he must start. It is not that always the prosecution must start the case. If the accused has taken the plea, he was suffering from insanity at the time of the commission of the offense, or it was a grave and sudden provocation act, then the burden will shift on him under Section 80, 82 of the evidence of the Indian Penal Code, read with 101. So you have to prove here. Now, he is desiring, you are desirous of the plaintiff, is desirous of informing the court that he asserts that he has a legal right. That means he has a legal right. I am the owner of the property. I have entered into an agreement of sale with the defendant who is a developer or a builder who promised to give me a flat. I am entitled to specific performance of the contract. So you are asserting a right. So what is your right here? That the contract between him and me is valid and subsisting. It's a conclusive contract. It's a contract which gives you a legal right under the provisions of both the Indian Contract Act and under the Specific Relief Act. So if that is so, you will have to prove the plaintiff who filed a suit under Section 10 of the Specific Relief Act for a declaration that he is entitled to ownership of a land, isn't it? He will lead evidence. So you will lead evidence that the agreement which has been entered into between me and the plaintiff, this is the agreement which has been produced at CL number 1. This is signed by me, signed by the builder. I have paid the consideration. The consideration are listed in the schedule. I have also mentioned it here. The contents are correct. Then this has been signed. Suppose if the defendant has taken the plea that I have terminated the contract, he has been committing breaches in the matter. So you are asserting a legal right. The other side, and you are also stating that the defendant is bound and liable to hand over possession. The liability asserting here, legal right assertion, you are trying to prove before the court of law that the contract which has been executed between you and me is valid and subsisting. So you are asserting your legal right here. So the burden is on you. Then at the same time, you take up the plea that the defendant is a rank trespasser. He does not have right title interest. So he is liable to be evicted. So that liability to evict is again in a suit where the plaintiff has filed for a suit for declaration or a suit for eviction, or maybe seeking any declaration, that the burden will be upon him in this matter. He is asserting a legal right. So you have to step into the box, and you can't tell the defendant, since you are denying, you go in the box first. No. If you are saying that the plaintiff has committed the act of subletting, you have to prove his subletting. You cannot tell the defendant, let him prove his right. No. So the burden will be, it depends upon the existence of the facts which he asserts, which we prove. And so there is no, what you call it here, one yardstick in all cases the plaintiff must prove. So from section 104, 101, what it's clear that here, the pendulum may shift from this side to that side. So I am giving you other example. So in the 101 case, the burden may shift like a open also order, the provisions of order 18 with the college. You come to know that. Order 18 CPC with Rakoli. Right to begin. Here the right to begin is right to lead evidence here. See, on a day fixed for the hearing of a suit on any day on which the hearing is adjourned, the party having the right to begin shall state his case and produce his evidence in support of the issues which he is bound to prove. Okay, this is the primarily liability is upon the person who filed the case, who has a right to begin. Now, who has a right to begin is not defined here. Now, in the suit filed by the plaintiff, defendant takes a plea that the present suit, the court has no jurisdiction at all to entertain and try the suit. The subject matter of the property is situated in Delhi. Both plaintiff and defendant are resident in Mumbai. One is plaintiff in Mumbai, another is in Bangalore. Property may be in Delhi. So you, on the basis of the provisions of section 18, 19, 20 CPC, you go and file a suit on the place that where the defendant is residing, and the last known address, and do carrying on business. He may be carrying on business. He's your brother. Huh? The property may be a family property situate in Calcutta or maybe in Delhi. So you cannot file a suit against your brother at a place where he is residing for recovery of the property, which is against the spirit of the provisions of section 16. He may take up the plea that the court has no jurisdiction, isn't it? So when the court has no jurisdiction, now the provisions of order 14 will come into play. Now, in order 14, the court may tell, the court may say, I will try this issue as an issue of jurisdiction, as a preliminary issue of jurisdiction under order 14, rule 2 check kare aap. Now, court to pronounce judgment on all the issues, order 14, rule 2. Notwithstanding the case may be disposed of a preliminary issue, the court shall, subject to provisions of 2, pronounce judgment on all issues. Number 1, where the issue of law and fact arise in the same suit, and the court is of the opinion, see, not you, plaintiff or defendant, court is of the opinion the case or any part thereof may be disposed of on an issue of law, it may try the issue itself relating to jurisdiction. Dekhiye aap. Number 2, bar. So jurisdiction, formerly it was 9A in Maharashtra, removed. Now here, if the court has no jurisdiction, why? Because a decree passed by a court not having jurisdiction is a nullity, cannot be executable. The court say, I should not like to waste time. Plaintiff is in Mumbai, defendant is in Bangalore, and the property is situated in Delhi. And how the suit can be filed in Delhi, when the suit can be filed in Mumbai or in Bangalore when the property is situated elsewhere. So the court will take up that the court, this is the issue relating to jurisdiction. So this issue has to be proved by defendant. Please note that issue of jurisdiction burden is the defendant takes up the plea. My lord, the court has no jurisdiction because the property is in Delhi. The defendant is the plaintiff is in Bangalore, defendant is in Mumbai. How the suit is maintainable? So following the provisions of order 18, the burden will shift here even according to the provisions of 101. So this is a legal issue. Then another example where the burden will shift is here, where the court will tell need not try all the issues, then a bar to the suit created by any law for the time being in force. Now, under the provisions of Arbitration Conciliation Act, will tell you parties are, there is an agreement of to reference the matter for arbitral, how he has filed a civil suit. So you will take up one of the party an application under section 10 before the court. My lord, this suit may not be tried because there is an arbitration agreement. There is an existence of alternate remedy available here. So the court will try the application on the application of the defendant under bar. A bar here is the bar created under the Arbitration Act. Now similarly, a bar is created under the provisions of order 23 rule 1 CPC. A previous suit was filed and he has withdrawn without liberty. When you withdraw the suit which was filed without liberty, subsequent suit is not maintainable. There is a bar. So defendant will take up the plea. So the burden has to be discharged by him. mean he has to step into the box, previous suit here, and that was the order of withdrawal, dekhiye, and he has not. So the burden is shifting upon the defendant. Now, similarly, the defendant will take up the plea. My lord, the present suit cannot be tried because it is hit by the doctrine of res judicata under section 11. Similar suit which was filed by the father of the plaintiff against the father of defendant was dismissed where evidence was recorded. I have a decree. So the court will say there is a bar created by virtue of section 11. This will come under order 14 rule 2b ke andar. So similarly, you may take up the plea that he had filed one suit in the district court at Delhi, which was dismissed. And at the time, he filed a suit only for the purpose of injunction. Now, in the second suit, he is claiming damages. How second suit is maintainable when the damages are based on the alleged defamation? That remedy was available to him in the first suit in the year 2000, but he relinquished that remedy under Order 2, Rule 2 CPC. So there's a bar under the provisions of Order 2, Rule 2, which says that if you have withdrawn the first suit or relinquished the portion of the cause of action, and you cannot file a second suit in the same way. So this will come. So in all these cases, the defendant ke upar burden will shift. Please note that here. These are the cases. Otherwise, when there are no previous suits and there is no such jurisdiction, there is no jurisdiction ke bare mein dispute nahi hai, the court is competent to try, then in the plain meaning, if it's a suit for declaration, suit for eviction, suit for a matrimonial dissolution of a marriage petition is very interesting. You know, husband may be in Delhi, wife is in Bombay. Parties under the Hama Act, under the Hindu Marriage Act, section 20 tells you petition can be filed and either the place where the marriage solemnized. Marriage was solemnized in Bangalore. Petitioner is working in Bombay and respondent is working in Delhi. Or the place where the respondent is residing. And the husband has filed a petition, for example, in Delhi. The wife is in Bombay. The marriage was solemnized in Bangalore. समझे ना, ये situation ऐसे सारे courts में आते हैं. So then what happened? The wife will make an application to the court. My lord, it is not possible for me to travel to Delhi. I cannot leave my job. I am in Mumbai. The marriage has taken place here, and request for transfer. That transfer petition is filed under section. Such matters in the different states. Delhi is a different state, Bombay is a different state, and Bangalore is a different state. And in the state district court or the high court doesn't have jurisdiction, you directly go to the Supreme Court. That is section 25 of the Code of Civil Procedure. Now the Supreme Court is flooded with such matters, the Supreme Court passing orders that let the application be filed, let the husband deposit money for air travel expenses, providing date of hearing, ये सब चीजें होते हैं. Okay, different. So the burden shift here in all such cases. So section 121 is like a pendulum. The plaintiff may be required to go some time in the box when he is asserting. So when there is no such legal pleas taken by the defendant with regard to jurisdiction, when the plea is not taken by the defendant that the suit is barred by res judicata, or under Order 2, Rule 2, the suit is hit by, or under Order 23, Rule 1-2 CPC, the earlier suit was withdrawn. In that event, the defendant will leave the burden. In criminal prosecution, under Section 82, that normally the public prosecutor begins the case when you open Section 225 CRPC. I'm just giving you come to know Section 225, 26 opening case for prosecution. In a trial before the court of session, when the accused appears as is brought before the court in pursuance of a commitment of a case under 209, the prosecutor opens his case by describing a charge brought against the accused and stating and what evidence proposed. This is the beginning is done by the public prosecutor. The matter doesn't come to the court of session directly. It travels from the court of the magistrate. the magistrate, after collecting the charge sheet under section 173, the police after completing the investigation under 176, 79 till 190 onwards, 189 onwards, he filed the charge sheet under 173. वो charge sheet पढ़ने के बाद the magistrate must be convinced that it's a case is triable by the court of session, then he will pass an order of committal under 209. Even magistrate has a power under the provisions of 209 to discharge, but normally they don't decline, they exercise this power, but sometimes they can do that. So it is the court of session, where session triable cases I'm talking of, the public prosecutor begins. Then if the court is satisfied, then only charges are framed under 228 ke andar. Then plea of the accused is recorded under 229. When the session judge, when the accused has not made the application for discharge under 227 or application having been discharged, the court will ask him whether you accept the plea, are you guna kabul karte hain nahi, that is 229 ke andar. Then nahi, I do not want to, I do not plead guilty, I not committed the offense. Then 230 ke andar prosecution, public prosecutor start the case 230 ke andar. That is how. Then after 230 ke baad, then the session judge, if he is not convinced, he may pass an order of acquittal. He doesn't even call upon the other side to lead evidence. So evidence for the prosecution starts at 230 and 231 CRPC ke andar, unlike the CR under the Code of Civil Procedure Code, where the provisions of Order 18 is taken care of here. Then defense enters later on when the court tells him, you want to say anything, you want to lead evidence. That's section 233 is the provision in a court of session. So similar provisions are couched in a warrant case also in chapter number 19, that before a trial, before a magistrate. Also in the provisions of that is a public prosecutor begins his case under 242, evidence for prosecution, isn't it? Then again, accused has a right to present application for discharge under 245 before the charges are framed here. Then defense lead evidence under 242 subsequently. But if the defense take up the plea that these all evidence will come under provisions of section 101. So you are asserting your liability, your some right, the prosecution will start. If the defendant takes up the plea that I have not done it, I am taking a plea, I was not available at the time of the commission of the offense, I was elsewhere, or I was suffering from insanity, I was a minor, whatever may be, child, then that burden will shift upon him under section 101. Okay, whoever designed the court to give judgment as to any legal right, depending on the existence of facts. So the fact depend which he asserts must prove that those facts exist. So the plaintiff must prove that here that the contract exists between him. There's a concluded contract. So you cannot file a suit for specific performance merely on a contract. All agreements are not contracts, isn't it? Only a concluded contract where both the parties are at ad idem under the Indian Contract Act, where there's a consideration between the parties to pay the money. Then you can move the court under the provisions of Specific Relief Act for specific performance of a contract under section 10 of the Specific Relief Act. File a suit. 10 and 15 of the Specific. Who can file a suit? Then remedies you seek under the provisions of Specific Relief Act, that is section 22 ke andar, all types of relief you can seek or are given here. So the plaintiff has to step and box and prove the document. So he is proving his legal right under the agreement. He is right to begin, he has to prove the document. And liability, that the defendant is bound by the contract. Defendant cannot take a somersault, it is not his signature. And he has paid consideration, isn't it? So that evidence you will be discharging here, the plaintiff who has filed the suit, you are asserting it here. It's evidence. Then next, when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on the person. So taking into consideration the language of the provisions of section order 18 of the Code of Civil Procedure and section 220, 226 of the criminal procedure code, and the provisions of section 231, evidence for prosecution. The evidence is required to be led in civil cases by the plaintiff unless the issue of jurisdiction is tried as a preliminary issue, or in the CRPC, it is the prosecution who will begin the case first if it's a sessions court triable case under the provisions of section 231 CRPC, or the prosecution will say that here the accused is admitting the crime, but he has taken up the plea of insanity under the provisions of section 82. That if you admitted the plea, but at the time of the commission of the crime, it was a grave and sudden provocation. So then the burden will rest on him. Whether he was suffering from any insanity, mental state of mind, so he will examine his own doctor file. What was his health condition? Prosecution will be asked to enter. So the session judge need not ask the prosecution to prove because he is admitting it. So the burden will shift upon. Now let us see the illustration. A desires a court to give judgment that B shall be punished for a crime which A says B has committed. So prosecution has been filed by A. The victim is represented through the state. So the state is A here, desires judgment to be given, punishment be given to B, who has committed serious offenses, maybe of murder, robbery, rape, whatever, maybe any charges. Then A must prove that B has committed the crime. So under the criminal law system, the burden of proof is always heavy on the prosecution. It cannot shift. Under the Evidence Act, the prosecution must prove the case beyond reasonable doubt, because you cannot take the plea that if A has not committed the crime, B must have committed or C must have committed. 3-4 people who were present in the room at the time of the commission. 3 friends were heavily drinking and boozing. एक को मार दिया किसी को गुस्से में आके, शराब के नशे में. One blow was given by him. He was removed to hospital. He collapsed and died. And who has committed? There is no direct evidence. And everybody says, I am innocent. Then on the basis of the forensic evidence, and on the basis of the direct evidence, if any, on the basis of the confession, if any, it is the prosecution which will prove the case beyond reasonable doubt. So just prosecution, just because cannot prove against A, no clinching evidence, शायद B क्या होगा, C क्या होगा? No. In a criminal case, may and but and preponderance of possibility will not do. There must be a direct evidence, same and except A, nobody else has committed the crime. It is better to let off 100 people, innocent people, than convicting one innocent man. That is the criminal law theory. You cannot, just because you cannot prove a charge against A, you cannot invoke liability against B or C in the matter. So you must prove. But whereas in civil cases are tried on preponderance of possibilities, which may presume, mostly it may happen, court may draw inferences. Even certain matters, even a criminal court can draw inferences in certain cases, like the accused is habitually residing or habitually proceeding in that direction, knowing friendship hai, the court may draw inferences. But as regard the attack committed, mara tha usko, as a result of the blow given, there must be a direct evidence, clinching evidence, either in the form of a direct evidence, confession, or a photographic evidence, or you may say medical evidence, CNA ka evidence. Without that, you cannot prove the case. Okay. Here the prosecution must lead evidence. Here the burden will not shift. The public prosecutor who opened the case under section 226 of the CRPC will start leading evidence under section 231 CRPC. Isn't it? The burden will not shift him. Now B. A desires a court to give a judgment that he is entitled to certain land in the possession of B by reason of the fact which he asserts, and B denies it to be true. A must prove the existence of the fact. Now, A files a suit for declaration that the suit plot of land belongs to my father. Upon the death of my father, I am entitled to ownership rights. Number one. The defendant is a rank trespasser. We do not have any privity of contract. He has trespassed into the land. He should be liable to be ordered to quit, vacate, hand over quite vacant, peaceful possession. Let the prayer be. First prayer, that this honorable court be pleased to declare that plaintiff is entitled to ownership of the land. So a declaration you are seeking, so you have to prove in whose name the original conveyance, your father's name, your name, grandfather's name, वो produce करेंगे आप. If the defendant is disputing your relationship with your father, advisable to also have your, if it is a will, get a probate or succession certificate or a heirship certificate, or some document to show that here you are the son of the original owner. There must be documentary evidence. If it's a seriously disputed case, there is a heirship certificate granted by the court. District court grants you, High Court grants you. Now, the provisions of Bombay and the Regulation Act ke hisab se, the earlier District Court and High Court used to grant. Now, every Tahsildar and every local court grants it. Better to always keep, when you're filing a suit, when you are a plaintiff lawyer, when your status is disputed with your father, go for a heirship certificate. Keep it ready. हाँ, अगर आपके फेवर में विल बनाए तो गो फॉर ए सक्सेशन सर्टिफिकेट और ए प्रोबेट बना के रखिए. Probate is granted to the heirs, isn't it? Probate is not granted to strangers. Executor applies it. Under the Indian Succession Act, you know that. So the property is distributed to the heirs and legal representatives of the person named in the will. Succession certificate is granted to the legal representatives, the family people, or even maybe bank for whom you are taken the loan. The expression legal representative is very wide compared to the heirs. Heirs are blood relation, the agnates and cognates. Whereas a legal representative can be a person, maybe a creditor, somebody who has lent an amount to your father, somebody, a mortgagee in possession. So यहाँ पे the burden is upon the plaintiff to prove that here I am the heir of the original owner. This is the heirship certificate. You also prove that I was born here. My birth certificate भी रखिए लाके. I went to school. My father admitted me in the school. In the record, my father has signed it, and my name is shown. Suppose in some villages there is no such provision, you are unable to obtain. Or examine some villagers, some people. Yes, I know his father. He is the son, whether he was born and brought up in the family. So you are proving your status. Then you may document बताएंगे land का 7/12 उतारा, easy, or a 7/12 extract, or any property document which the Registration Act permits you. Every state has got different names. In Maharashtra, they call it here 7/12 utara, 7/12 extract, 6/12 extracts, deed of conveyance. So deed of conveyance, a registered document is a proof itself. Under the provisions of Registration Act Section 30, the court will take cognizance, the constructive notice that registered document is valid. It cannot be denied. Isn't it? So A registered document of conveyance which is not in your possession, you can obtain certified copy under section 63(1), read with section 74, public document. It becomes a secondary evidence admissible. You may say that here the original is lost, lying in the registry. I could not trace it. I made application. I obtained the certified copy from Tahsildar ki office. So you are stepping into the box, proving your relationship to the land, proving your relationship whose son you are, proving your that right title interest is vested in you, and lead evidence. The defendant, I do not know, out of the blue he has come. There is no privity of contract. We don't have any contract with him. Or if he was merely a servant working with my father during a lifetime, he doesn't have any legal right. His services were terminated. He was an estate manager looking after the estate. An estate manager or a servant, by no stretch of imagination, can claim any legal right. He is liable to be beat. So that is the burden you have discharged here. You must prove the existence of those facts. Understood? So your relationship with your father, by getting heirship certificate, all relevant documents. If no heirship certificate, your probate, or maybe school record, maybe your passport, maybe your Aadhaar card, family card, ration card, examining local witnesses to prove your relationship, or the place where you're born, in hospital, birth certificate. ये सब चीजें, these are all valid document to prove your relationship. Then land के लिए, from where it is purchased by your father or purchased by you, consideration. A registered document goes inside immediately. It's a primary evidence under section 62, which is sought to be tendered by you under 64. It will be admitted by the court. So you discharge your burden. Yeah, okay. So this is you. Both the illustrations are now clear to you. Anybody want to ask any question? 101 mein. I will take now 102. On whom burden of proof lies? Now, 101 gave you a general illustration, a pendulum. Whoever asserting a legal right and whoever want to prosecute, that must give evidence. Now, on whom the burden lies? A specific person. Somebody must have tendered some document. Somebody must have taken up certain plea. Now see, the burden of proof in a suit or proceeding. Suit means civil cases. Proceeding means it can be criminal case, arbitration, MJ petition, all types of cases. Family court proceeding, consumer court proceeding, labor court proceeding, all proceeding. Evidence Act means wherever the act is applicable. Wherever the act is applicable. Nowadays, whether applicable, not applicable, even I see arbitrators in India are using Evidence Act. Though before the Arbitrator Evidence Act is technically not applicable. They are not bound by it. But almost every arbitrator where I am appearing, they are following the entire Evidence Act and CPC. It's become like a mini trial. To be frank with you, arbitration is become almost a camouflage proceeding. समझे ना, कहने के लिए is a proceeding under arbitration for disposal as early expeditious. No, sorry to say that the arbitration is like a what you call it here is a parallel court. Exactly parallel court. Proceedings are taking donkey's years. 2 साल, 3 साल, 4 साल, 5 साल. Dates are here. People are fed up. Clients are fed up paying money to the arbitrators and the council. And arbitration is a failure. I would say that. I think court system is better. The court must increase the more courts and more judges. That would be more preferable to go, because you can cut down your cost. Now, the burden of proof in a suit or a proceeding lies on a person who would fail if no evidence at all were given on either side. Very interesting. We'll see the illustration. The burden of proof in suit or proceeding lies on a person who would fail. So he is not discharging the burden, the plaintiff. And the prosecution is not proving the case. No evidence at all were given on either side. Now plaintiff ने दिया है, ना defendant ने दिया है. What would the court do that? Then what? How will you argue the case? Now A sues B for land of which B is in possession, and which A asserts was left to A by the will of C, B's father. Very interesting. So litigation between A and B with regard to the property of C. C is the father of B. So in what capacity he is in occupation, we do not know, not disclosed so far here. He is in maybe possessory possession. Now under the specific relief act, you can be in a possessory possession. Title is not required if you are dispossessed without due process under section 6. Now let us see. If no evidence is given on the other side, B would be entitled to retain possession. Because the person already in possession. A has filed a suit against B on a land which is B in possession, and B claims, assert that it was left by A, as assets was left by A by the will of C, B's father. So pursuant to the will, he is entitled to possession. Whether the will was probated or not probated is $1 million question. That means no evidence is let in, the will is not probated. If no evidence is given on either side, so merely suit is filed is not sufficient. And even if you are tendered the will in the court of law, is not sufficient. You must enter the box to lead evidence. Therefore, the burden of proof is on A. So the person who has filed the suit, A, has not gone in the box. Now, B being in possession will retain possession, because suit stand dismissed for non-prosecution in a given circumstances like this. Because you cannot dispossess any person without due process of law. And a person who is in established possession cannot be removed for any reason. You must remove him, giving a reason why you want to evict him. That I am the true owner. And he is a trespasser. Or he was my licensee, license is revoked. Or he was my tenant, he has committed breaches under the rent control legislation. वैसा कुछ नहीं यहाँ पे. So you are merely filing a suit and not stepping into the box, and evidence is not given, and evil suit will remain. The burden is actually on A because he has filed a suit for removal. Then see, the execution of the bond, then next देखिए. The burden of proof is on A here. Then A sues B for money due on board. A commercial suit under the Negotiable Instrument Act, or maybe a summary suit under the provisions of Order 37, Rule 1 and 2 of the Code of Civil Procedure. Okay. A sues B for money due on bond. The execution of the bond is admitted. So B in the written statement says that yes, it is true that this bond is executed. But B says that it was obtained by fraud, which A denies. यहाँ पे burden will shift upon B. The defendant is taking the plea. Yes, it is true. I took loan. It was on the execution of the pro note, which I am not disputing. But the document has been got executed fraudulently. Now, the provisions of CPC tells you, Order 6, when you plead fraud and misrepresentation, particulars must be given. Padhe aapne, isn't it? Order 6 is the CPC. If you go back, particulars of fraud must be given here. So here the defendant takes up the plea. Then if no evidence was given on either side, look here, A would succeed as bond is not disputed and A, the fraud is not proved. So the B should have stepped into the box. It was the duty. Now under the provisions of order 18, the burden will shift upon the defendant because he is admitting the document execution of the bond. So no evidence is required. You have taken the plea. For first plea, execution के लिए तकलीफ नहीं. But the important plea is taking, it was got executed under misrepresentation and fraud. Uske liye you require to lead oral evidence as contemplated under the provisions of section 92, proviso 1 to the Evidence Act. Isn't it? How fraud is committed is not going to tell. आपने पढ़े आपने 92 खोल लीजिए यहाँ पे. Proviso 1, any fact may be proved which would invalidate a document, which would entitle any person to decree or order relating to the two, such as fraud, intimation, illegality. So यहाँ पे defendant, the Janab defendant doesn't appear in the box. So he is not discharging the burden. Plaintiff need not prove the case. The court will pass a decree on admission. पढ़े आपने order 12 के अंदर CPC में there will be a decree on admission, isn't it? He is admitting that yes, the document I have executed, the pro note. But second line, this has been fraudulently got executed. But unfortunately, you are not, both the parties are not given evidence. Here the evidence ought to have been given by defendant and not by the plaintiff. See, in a normal course, the plaintiff who filed the case under order 18 must step into the box and give evidence. So, but यहाँ पे दोनों evidence नहीं दे रहे. The court is deciding the case on the basis of the plain and written statement. Now, under order 9, the court has power to decide the matter when no evidence is led by both the parties. So the court will note here the defendant having admitted the claim, I am passing a decree under the provisions of order 8 rule 10 and order 12 of the CPC, decree on admission. Because the defendant has not stepped into the box to challenge the document on the ground of fraud and misrepresentation. There is no evidence. On the contrary, there is an admission. So section 17, 18, 19, 21, 22, 23 Evidence Act tells you admission kya hai. Isn't it? Admission can contain in written statement. Admission can contain in pleadings. Admission can be implied. It can be on your correspondent. So this admission cannot be taken away. So यहाँ पे the defendant should have led evidence. The burden was on him. Even if you read the provisions of order 18 carefully, the burden was on him and 102. Okay. Okay, anybody wants to ask me question before I turn to 103? Yeah, 103. कहां तक लेना है बोलो मेरे को कुमार. Yeah. Burden of proof as to particular fact. The burden of proof as to any particular fact lies on a party who wishes the court to believe in its existence unless it is proved by any law that the proof of that shall lie on any other person. It's a very interesting section. Burden of proof as to any particular fact lies on a person who wishes the court to believe in its existence. So normally it is the person who asserts that this particular document has been fraudulently executed. Fraud has to be proved by the person who asserts it. Unless it is provided by law that the proof of that fact shall lie on any other person. So any other law may tell you that the burden will shift. Now let us see the illustration and to understand this question. A prosecutes B for theft. So an offense under section 379, 380 IPC, and wishes the court to believe that B admitted the theft to C, A must prove the admission. Now admissions are admissible both in civil cases and criminal cases. Now here section 17, 18 is sought to be invoked here. So A is placing on record, A prosecute B for theft, that my neighbor, my servant, I am filing a FIR against my servant who stole certain valuable item from my house. Computer चोरी करके गया. The same servant also works for my neighbor, to whom he informed that ये मैंने कंप्यूटर यहाँ से चोरी किया, बताना मत साहब को. समझे ना? So there is an admission. So यहाँ भी अंदर B wishes the court. Yeah. In that case, admission left to the A must prove the admission. So it is my responsibility to bring my witness, my neighbor. I will have to issue witness summons. Tell the magistrate, my lord, be pleased to issue witness summons upon my neighbor who wrote me a letter. See, this is the letter, email he sent me, or a WhatsApp message, which he said that your servant who also works for me told me that he stole your laptop as he wanted this to be used for his school going son, daughter. That is. So I have with me that particular message. That mere message is not sufficient. I must examine the gentleman by issuing it as summons to him, or if he is disputing, he doesn't want to come for some reason, of course you have a right to issue warrant. You have a right to also examine this particular message which you received it on your mobile phone by obtaining necessary certificate under section 65 of the Evidence Act to prove that such message was given. Okay, that particular fact burden is shifting here. Okay. Number B. Where are we? 103 minute. Then see, in the same, a particular B wishes the court to believe that at the time in question he was elsewhere. He must prove it. So now he is taking a plea of alibi. So when a prosecution is launched against him that you have committed the offense of robbery or a theft in my house on 1st of January 2020. 2020, I was not in Bombay. I was in Calcutta. I was in Lucknow. So evidence is sought to be laid. So the burden is shifting upon him, the defendant here, the prosecution, from the prosecution to defense. Because a particular fact is a fact which is only known to him. The court is not going to presume. So section 7 में 11 में पढ़े हमने, facts which are inconsistent can become relevant. Inconsistent, contradictory facts can become relevant. So commission of the crime is committed in Mumbai. After 3-4 days, the accused is arrested. Accused will say that I should be released on bail, and the entire prosecution story about my involvement is wrong. On the date of the alleged offense, I was not in Mumbai, I was in Delhi. I am prepared to prove it. So the entire prosecution is false. So जब trial शुरू होएगा, so you will bring your relevant plane tickets. Where were you there? What were you doing? You were working in a company ka letter. If you are giving exams, examination ka proof. So 103 will tell whoever takes up a plea, this particular evidence is not correct, or the prosecution, the correct is this way. So in the earlier the second case, the plea of alibi is taken. Now in the earlier case, admission of this friend. So my servant has made an admission to my neighbor that he has stolen the articles. So but that becomes necessary to, because the prosecution need not. That man is silent, because right to be silent is one of your fundamental right, isn't it? You are not supposed to speak. If you are an accused person, need not speak. If you speak, better to keep your mouth shut, because it is the prosecution is required to prove the case beyond reasonable doubt. If you don't know your case, and if you are a defense lawyer, if your client is guilty, don't say anything. Just keep your mouth shut in the court. Let the prosecution talk. It is only when your turn comes under 311, 315 CRPC, jab aapko, you have to give the evidence or statements throwing light on the circumstances of implication, which you may deny, which the court will put question to you. So at this stage, you need not say that. So that is how this section 103 is a section more or less protecting both the parties, especially more of the defendant. I mean, this shift the burden upon the other side. So at the time of the commission of the offense, I was not there. Khatam. So similarly, 103 may defendant will take up the plea. Fact that here, this suit is not maintainable because there is already a previous decree. So a particular fact, the defendant has to prove this. 103 के हिसाब से burden is shifting on the res judicata. Former suit has been decreed and it dismissed. And why second suit for possession again? Between the same parties or the agents. So you are asserting it. Whether the previous suit filed by was your father, grandfather, that you have to prove before the court of law. Other side may take up the plea. He is a fictitious person. He was a servant working in the family and he is falsely claiming to be his son. So ये सब issues आएंगे कोर्ट के अंदर. So 103 के अंदर shift हो जाएगा. So time is there to continue or we want me to stop, Kumar? बताइए.
Sir, we can continue if you are comfortable. We can take up till 8:30.
We can take. Yeah, चलो 104 पे आ जाइए. Burden of proving fact to be proved. Burden of proving fact to be proved to make evidence admissible. Burden of proving fact to be proved to make evidence admissible. How the evidence is admissible and whose burden? See, the burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. So A is trying to pass on the evidence to B and C and D. They are in possession. It is his responsibility to bring the evidence. Let us see. A wishes to prove a dying declaration by B. A must prove B's death. So you just cannot rely upon the probate of your grandfather or a dying declaration statement of XYZ unless the factum of death itself is proved, isn't it? There cannot be dying declaration under section 32 of the Evidence Act, there are 8 circumstances, A, B, C, D, E, F, G, H, 8 circumstances where evidence of a dead person or person not available can be recorded. So person, you have to first lead evidence to show before invoking the diary of a dead person admitting your claim. पहले तो बताइए कि when, in which year he died, in which year you gave him loan, how did you come across his writings, his acknowledgement. So you are required to first prove the death, then thereafter only his declaration can be proved. Factum of death, even the criminal prosecution cannot start unless proved that A had committed the murder of B. Where is the B's dead body was found? Was any forensic record is there available? Autopsy report क्या है उसका? Sometime body जलाई जाती, proof मिटाया जाता है. Still the courts say that here, if evidence is brought before the court that would causing disappearance of the evidence. So under 104, you are seeking to rely upon dying declaration under 32, 1, 2, 3 to 8 person. To rely upon the dying declaration, the burden is on you to first prove that the man died before making the dying declaration. Okay, that burden. Then A must prove that the document has been lost. B देखिए, A wishes to prove by secondary evidence the contents of a lost document. This is a very interesting section. Burden of proving fact to be proved by making evidence admissible. Necessary to prove in order to enable any person to give evidence of any other fact is and a person who should. So 104 के हिसाब से you may take up the plea that this honorable court be pleased to permit me to lead evidence of secondary evidence Xerox copy. Xerox copy will not be straight away allowed to be introduced with the court of law unless you prove that number one, lead a foundation. Where is the original? Section 62 tells you primary evidence kahan hai? It is lost. Foundation lodge कीजिए, lost. Did you lodge a FIR? Misplace. I began searching it every place. I made efforts to trace it. I even lodged a FIR. पुलिस को बताई मेरे घर में चोरी हुई थी. Produced it in the court. Or you took up the plea that year. I am producing secondary Xerox copy of the agreement of sale, the original of which is in the possession of the builder, which is not giving me. Your copy will not be admissible unless you tell the court that the original is in the possession of the builder. That you wrote a letter under section 66, gave a notice to him. Because section 66 tells you, no, you have to give a legal notice to the person in whose possession the original is, calling upon him to produce the original at the date of the recording of the evidence. Please note that the matter is kept for recording evidence. I have filed my examination chief and list of documents. Under the list of documents, serial number 1 is the agreement of sale between you and me, the original of which is written with you by you, because under the guise of registration, you took me and you said that the document is sent to Pune or some other place for registration, not written. You are hereby called upon to produce the original. You had only given me Xerox copy. Xerox copy is not sufficient. So you must prove before the court of law that the document is original is in the custody of the defendant. So under the provision of Order 11, Rule 13, affidavit में लिखे होंगे आपने. This document is not in my possession of the defendant or registrar. I gave a notice to them to produce it. I tender here, at the time of statement, क्या बोलेंगे? I am tendering here the legal notice which I gave under section 66 of the Evidence Act, calling upon the builder or the registry, requesting them to produce the original my lord. And there is no reply so far. The court will say the document is taken on record. It has the endorsement of the builder's office, sent by registered AD. Court will ask the other side, do you have any objection? Have you received? Yes, we have received it, but we have not replied it. Court will ask him where the document. I don't know. Then court क्या बोलेगी? Yes, the plaintiff has laid foundation to take on record the secondary evidence because he had discharged his burden under the provisions of section 104. He has proved that the original is not in his possession, and he has proved that he has given notice to the builder or registration office to produce it, and they are not complied with the request, and hence I am taking on record this secondary evidence. It becomes admissible. That we have dealt with it. So this is a very important section. You have to connect it बाजू में लिख लीजिए for proving section 63, 65 of the Evidence Act and 66. 63, 65 and 66. 66 is concerning notice. Okay. This is very important. 104 का first illustration, dying declaration. Section 32, clause 1. The victim, the wife, wants to state before the court, my husband gave, before going to the house of the accused, he had told me he is going to settle the family dispute which is pending in the court of law. He called him for dinner and he never returned back. So she is narrating the circumstances relating to his death. So the statement of the wife will be a dying declaration which was made to her before his disappearance. Or the dead person who suffered injuries on the road made a statement. One black car came and dashed me. I know that that black car belongs to my opponent who had filed a case. He wanted to eliminate me. Purposely has done it to kill me. And after 2 hours, he dies. So the statements made to the doctor or to the nurse are dying declaration. Those statements can be used by the wife and the prosecution both for convicting him in the criminal court to prove that he died and prior to his death he had made this declaration. In a civil case where the matter is going on, also the wife can lead evidence to that effect here. On account of the pendency of the present suit, the defendant wanted to kill him, and he in fact did. And my husband has made this statement here. Accordingly, I am producing the dying declaration and also examining the doctor. So the factum of death, you are proving it, number one. So to prove one fact, you need to prove another fact. Like in the case of a secondary evidence, you cannot just enter the secondary evidence without first laying a foundation as to where is the primary evidence, how it disappeared, why it is not in your possession, what remedial steps did you take to procure them. Okay. And for proving a dying declaration, when the man died, under what circumstances he made that statement relating to his death or relating to the transaction, business transaction, or whatever may be, the circumstances mentioned in 32, 1, 2, 3, 4, 5, 6. Some customs usages prevailing in the community was mentioned by elderly man who died later on. So it's a declaration, dying declaration. If the custom evidence is admissible of a dead man who was a Gram Panchayat president, He had made some hand mark that he stated in the Gram Panchayat book that village people have a right to go, have a right of egress and ingress to the temple which is situated, which everybody has to pass it from the private land of the plaintiff. Sanjana. So that Gram Panchayat president who has made these are the declaration admissible under the provision of 32. So you can prove he's dead now. So he died last year. You can prove that. उसका क्रिया क्रियम हुआ था, पेपर में आया था नाम. Dead होने के बाद those statements become admissible. So 104 attaches is a very interesting section in order to prove. So like 103, special facts you have proved. Particular fact, when you take up the plea of alibi, so the burden is shifting on you. You prove it. 104 के अंदर, so you are leading. You want to, prove one evidence. There are two types of evidence. First, prove the evidence with regard to death before claiming any right based upon the death. Right? Similarly, the case when you want to rely upon secondary evidence, first prove what happened to secondary evidence or what happened to primary evidence. Because section 62, 64 mandate, it is the first duty of the plaintiff or defendant to prove the best evidence. Second, primary evidence लाइए पहला. अगर वो नहीं रहेगा तो then you are permitted to bring the secondary evidence. Okay, it's now clear. Now 105 पे आ जाइए. Burden of proving that case of the accused comes within exceptions. Interesting. When a person is accused of any offense and the burden of proving the existence of the circumstances bringing the case within general exceptions in the IPC or within any special exception or proviso containing in any other part of the same code or in any other law defining the offense is upon him, and the court shall presume the absence of such circumstance. So generally, under the scheme of the CRPC, it is the public prosecutor, the prosecution which has to first open the case, prove the case beyond reasonable doubt, and the burden is upon them to kill. But if the defendant says that I am admitting the crime, if the accused says I am admitting the crime, but at the time of the commission of the offense, I was insane. Open section 82 of the 80 of the Indian Penal Code, general exception. Section 76 से शुरू होता है, general exception. Now, to understand the illustration, the provisions of section 105, please directly come to the provisions of Indian Penal Code, chapter number 4, general exception. (76) says, nothing is an offense which is done by a person who is a reason of mistake, has no reason or mistake in law or good faith, believes himself to be bound by like. So I am not wasting my time here. Come to 84. Act of a person of unsound mind. So we took in the plea that on account of insanity and sound mind, he will take up the plea. Yes, at the time I did not know the nature of the offense. Nothing is an offense which is done by a person who at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that who is doing it either wrong, contrary to wrong. बोलेंगे I was suffering from insanity. I did not know neither. I was heavily intoxicated. Section 82 tells you nothing is an offense which is done by a child below the age of 7 years. These are the जनरल एक्सेप्शन. और इसके अंदर भी व्हाट इज दैट ग्रेव एंड सडन प्रोवोकेशन, वो किधर आएगा? which section in the IPC? just see. Act was done in grave provocation. Which one? 79, 80. So all these sections starting from 76, 77, 78, 79. So ये सब burden is shifting upon the person. So some 88 से लेकर act done in good faith. Then 90, 92, 93 good faith. All is good faith. 94, 96 private defense. 98 99 right of private defense when there is a no right defense, extent to which there may be access. So these are the general exceptions starting from section 76 से लेकर 100 till 106 तक IPC के अंदर. So the burden is shifting upon the other side. Now this is what section 105 says.
Section 300, exception 1 talks of grave and sudden provocation, sir.
Yes, section 300, is it? You're right. Yeah, that is also an exception. Somebody kills somebody in a spur of the moment. Like, for example, if A has seen B in a compromising position with his wife, he comes and immediately मार देगा, दोनों को ही मारेगा, एक को मारेगा. So he will take up the plea. It was sudden rage. I did not know. So that he will be out of the clutches. That is 105 will come. So the burden will be upon him to prove it. Okay. This is the, now let us see the illustration. A is accused of the murder, alleging that by reason of the unsound nature of mind, he did not know the nature of the act. So that we read it right now, section 82. The burden is upon A. Now the burden is shifting upon the, not upon the prosecution, but upon the defense, upon the accused. Okay. Then A is accused of murder, alleged by grave and sudden provocation, he was deprived of the power of self-control. Then the burden is upon the A. So that is the exception to 300 and here. They give you. Then section 325 of the Indian Penal Code provides that whoever accepts in the case provided by 335 voluntarily causing grievous hurt shall be subject to certain punishment. A is charged with voluntarily causing grievous hurt under 325. The burden of proving circumstances bring the case is on the A. So these are the cases: plea of insanity, sudden and grave provocation, self-defense. They're all burden shift. Section 105. Prosecution did not prove because यहाँ पे you're admitting the crime. But you want the court to let you off for other reasons. You're out of control. You are insanity. You are a child, and various exceptions which are available to you under the IPC. Okay, so this is quite easy. This is called shifting of the burden. Yeah. 106 आ जाइए. Special fact के बारे में. Burden of proving the fact specially within your knowledge, within the knowledge. When any fact is specially within the knowledge of any person, the burden of proving that fact is upon him. So the special knowledge is only known to you, nobody else. So you have to come out and tell the court the illustration given is of a nice, in a railway platform, you are caught without a ticket. So he's not going to presume you have a ticket or no ticket. So he has a right to do his duty. Then you have to show that, yes, I am a valid ticket holder. I got my, that's a special knowledge within you. Let us see the illustration. When a person does an act with some intention other than which the character and circumstances of the act suggest, the burden of proving the intention is upon him. So, by virtue of section 106, the burden of proving the intention and the act committed, and as well as the character and circumstances of the act, suggesting the burden, proving the intention is upon you. So this is a little more complicated. Burden of proving the intention is under the provisions of section 8, evidence with regard to intention, good intention, bad intention, malified intention is upon. Defamation suit is filed, you will say that I had done it in good faith with good intention. So that good intention, you have to, burden is on you to prove, isn't it? Now illustration B check karenge is very interesting. A is charged with traveling on a railway without a ticket. The burden of proving that he had a ticket is on him. So naturally, the TC who is standing at the platform is not going to presume or imagine that आपके पास ticket है नहीं है. Just have a suspicion on someone is trying to run and go fast, the police, he will catch you. अरे वो मेरे पास टिकट है क्यों पकड़ रहे, मेरे पास I am a pass holder. वो बोलेगा please show the pass. नहीं मैं दिखाऊंगा नहीं pass. I don't have it in my house. You will be charged. Either you pay the penalty or you will be arrested. You will be taken to the railway police. The railway police will take you to the railway magistrate. So you may tell the magistrate, I had the ticket, I had it, I have it. But you had that burden is upon you to prove that. I have a ticket or a pass. The railway examiner is not going to prove it. So similarly, the intention, the evidence of intention, which is normally led under section 8, motive, preparation, and subsequent conduct, your conduct. Ill will, good will, वो भी पढ़े आपने section 14 के अंदर, isn't it? Under the provisions of section 14, we learned the evidence of state of mind, bodily feeling, goodwill, ill will, ये सब चीजें. So when a defamation suit is filed, you may say that my intention was not to do that. I have done a defense लेंगे आप illustration के अंदर. It was done in good faith. A good faith, whether you have a good faith or bad faith, the court is not going to presume, police doesn't know. That burden is upon you to prove it. So if you take up the plea, newspaper में आया, you are indulged in a campaign of vilification against the complainant. You have alleged very badly. You would say, my lord, whatever I have said is truth. Whatever I have said, truth is a defense in the Indian law, you know that. And as a public servant, he has taken a lot of robbery. He has taken a lot of bribe from various people. I can prove that fact. He is hurt and he filed a suit for defamation against him. And I said it because I have a proof. And he is not discharging his duties correctly as a public servant. I said it in good faith to bring to the attention of public. So a good faith, a ill faith, that what was your intention? That is specially known to you. So that is 106 के अंदर पढ़ डालेंगे. 110 तक ले लेंगे, 7 पे आ जाइए. Burden of proof.
We can wrap up at 41.
हाँ जी. बंद करेंगे अभी?
Sir, I was suggesting if we could wrap up. Yes, sir, it's 8:41.
ठीक है, बंद करो अभी, बाद में देख लेंगे नेक्स्ट लेक्चर अभी. All right, our lectures will take long time. Yeah, okay. Why, anybody want to ask any question? पूछ लीजिए. Anybody has any question? I will take your next lecture on Thursday, not tomorrow. Tomorrow I'm in difficulty. I'm available Thursday and
Okay,
Friday. Thursday and Friday, both days available. No? I can take both the days and we can wind it up your chapters. We can go ahead. Okay. Chalo, good night.
Sure, sir. Good night, sir.